Welcome to our California Real Estate Exam Prep video series. We'll give you 20 daily practice questions for the next 100 days with detailed answers to help you pass the exam and get your license. If you like our videos, please like and subscribe. Let's start now. 1. All of the following can distinguish if an item is a fixture in a transaction, except A. Relationship between parties. B. Agreement between parties. C. Method of attachment. D. Impression given by owner. Answer D. This is a simple question. Remember MARIA method of attachment, adaptability, relationship of the parties, intention, and agreement are all tests to determine if an item fixture. 2. A seller decides that he is not going to go through with a sale during escrow and instructs broker to return the deposit to the buyer. What should the broker do with the deposit? A. The broker should keep it as security towards her commission. B. Return it to the buyer. C. Give half to the seller and keep half for herself. D. Return half to the seller and half to the buyer. Answer B. The broker should always return the deposit to the buyer if the seller cancels the contract. 3. If a buyer rejects a counter-offer, the seller should A. Accept the original offer as long as it hasn't expired. B. Accept the original offer as long as it is within 30 days. C. Do nothing. D. Approach the buyer with a new offer. Answer D. The seller may do nothing or approach the buyer with a new offer. Four. A broker's unlicensed assistant performed the following actions. Which should not have been done? A. Called and arranged a pest inspection from a list of companies the broker provided. B. Arranged to meet the inspector at the property and let him in. C. Prepare documents for review by the agent. D. Answered questions about material facts of the house that an inspector asked. Answer D. Answer choices A through C are all permitted activities for an unlicensed assistant to perform. D. Is beyond the scope of an unlicensed assistant. An unlicensed assistant should not do anything that may directly assist or aid in the negotiations or closing of a transaction. Further, it is only a licensed agent who has the authority to make representations of facts. Five. When can the selling agent fill out the transfer disclosure statement? A. When the buyer instructs him to. B. Anytime. C. After the agent has inspected the property. D. When the seller instructs him to. Answer C. There are two sections in the seller's disclosure: the real estate transfer disclosure statement and the seller's supplement to the real estate transfer disclosure statement. Both are filled in by the seller without material assistance, e.g. prompting, from any agent. The seller's and buyer's agents are required to perform a competent and diligent visual inspection of the property and then complete the agent inspection disclosure, which is a section of the transfer disclosure statement. Six. Ethics is most nearly defined as A. Knowledge and respect of the law. B. Effective and efficient business practices. C. Dealing fairly and honestly with the public and clients. D. Respect and esteem of peers. Answer, C. 7. The maximum amount of a broker's commission is A. Determined by local custom. B. 10%. C. Negotiable. D. Defined by law. Answer, C. The amount of a broker's commission is always negotiable and is usually written into the contract. If no amount is stated in the contract, the commission paid by local custom is generally considered to be the implied amount of a broker's commission. Eight. Which of the following is considered to be real property? A. Stock in a mutual water company. B. Crops not yet harvested. C. Fruit in an orchard that will be harvested and is under a contract of sale. D. Minerals which have been mined from the ground. Answer, A. Mineral rights are considered to be real property, but once the minerals have been removed from the ground, they become personal property. Crops that are under a contract of sale are considered personal property. Crops, which are agreed to be severed before sale, are also considered personal property. Stock in a mutual water company is always real property. 9. Land is acquired by accession when A. Succession by intestacy. B. Buyer accedes to all conditions in the contract. C. Imperceptible action of natural waters adds to land by accretion. D. By acquisition of deed, grant, warranty, or bargain and sale. Answer, C. 10. What is infill? A. Demolishing old low-density housing and replacing it with high-density housing. B. Taking vacant or dilapidated urban properties and developing them. C. Taking vacant land in the outskirts of suburban areas and developing commercial properties. D. Taking old contaminated industrial sites and cleaning them up to develop recreation areas. Answer, B. 11. All of the following terminates an agency relationship except A. Mutual agreement. B. Renunciation by the agent. C. Expiration of the subject property. D. Renunciation by the principal if the agent has an interest in the property. Answer, D. Both exclusive agency and exclusive right to sell listings must have a termination date. An open listing generally has no termination date. The principal cannot revoke agency if the agent has an interest in the property. The right to earn a commission does not create an interest in the property. In general, agency can be terminated by mutual agreement, renunciation by the agent, revocation by the principal, if the agent does not have an interest in the property, expiration of the terms, completion, extinction of the subject, death or incapacity of the principal or agent. Also note that if agency is terminated early, there may be a claim for monetary damages. A real estate licensee may legally do all of the following except A. Accept an open listing that has no termination date. B. Receive a fee for servicing a loan that was negotiated by him. C. Sell his own property and claim a commission as an expense for income tax purposes. D. Claim a commission on an exclusive listing which does not include a specific termination date. Answer: D. Both exclusive agency and exclusive right to sell listings must have a termination date. An open listing generally has no termination date. Unless otherwise specified, the rights to minerals which lie beneath the surface of land A. Are automatically transferred with the sale of the real property. B. And not be leased. C. Are kept by the original owner. D. Require a separate title. Answer: A. Mineral rights can be leased or conveyed without the real estate but automatically transfer with the sale of the real property unless otherwise conveyed. 14. Gary purchased a new home from XYZ Builders, financing it with a loan insured by the FHA. 3 years later, he sold the property to Sam for all cash. Assuming the documents in these transactions have been properly recorded, the county recorder's files would disclose all of the following documents except A. Grand deed to Gary. B. Deed of reconveyance to Sam. C. Deed of reconveyance to Gary. D. Deed of trust. Answer: C. Since Sam purchased for all cash, there is no deed of trust from Sam to anyone, and therefore there is no need for a reconveyance deed to Sam. 15. Broker Brown took a listing on a 10-unit apartment house and wrote up a financial analysis showing a 12% yield on the investment. In the analysis, Brown did not allow for a vacancy factor, maintenance expenses, or reserves for replacement of furniture and equipment. Brown showed this analysis to Smith, who bought the property on the basis of Brown's analysis. Brown's actions are: A. Acceptable. B. Unethical. C. Unlawful. Answer: C. Broker Brown misrepresented the property to the buyer in that the 12% yield was based upon an incomplete analysis of the expenses involved. 16. When a broker decides to use a fictitious business name, before soliciting business using that fictitious business name, the broker must A. File a fictitious business name statement with the city in which the broker's main office will be located. B. Register the fictitious business name with the California Secretary of State. C. Publish the fictitious business name in a newspaper of general circulations. D. Hold a license from the Bureau of Real Estate bearing that fictitious business name. Answer: D. D is the best answer choice of those listed here. A broker can operate under a fictitious business name only after the CalBRE issues a license bearing the fictitious name. Before the CalBRE will issue the license, the fictitious name must be filed with the county in which the broker will operate. The name must also be published in a newspaper of general circulation as a condition of filing. While choice C is technically a correct answer, D is a better choice because it is more specific. Simply publishing the fictitious business name is not sufficient. The CalBRE must also issue a license bearing the fictitious business name. 17. When an owner acquires land with riparian rights appurtenant thereto, such rights: A. Give the purchaser absolute ownership of adjacent waters. B. Must be expressed in the deed. C. May be determined accurately from an examination of public records. D. Are only available to land adjacent to a stream and within the watershed. Answer: D. Riparian rights run with the land, so they are automatically transferred with the property and are not specified in the public record. Riparian rights do not convey absolute ownership, but only the right to a reasonable amount. When you use property to secure a loan but aren't required to give up the property possession, it's called A. Collateral, B. Hypothecation, C. Default, D. Security. Answer B. To hypothecate is to provide title to a property as security for a loan without giving up possession. 19. Which of the following best defines a commercial acre? A. An acre in a commercially zoned area. B. The portion of an acre of newly subdivided land remaining after dedication for streets, sidewalks, parks, etc., on which a developer is free to build. Answer B. 20. Which of the following does not usually result from a commercial sale-leaseback agreement? A. Largely for commercial buildings where large business concerns are involved. B. Company sells the building back to the financiers, and then leases the building back from them. C. Company increases its working capital. D. Building depreciates in value. Answer D. A commercial sale-leaseback occurs when an owner sells his or her property to another party and leases it back for a stated period of time. The original owner then becomes the lessee. Thank you for watching. I hope you found this video helpful. If you did, please consider subscribing to our channel so you don't miss out on our future videos. We look forward to seeing you in the next one.